Stop. It is also seen that written objection has been filed to the application under section 389 CRPC. Stop. As LCR has arrived, registry to prepare the paper book. Paper book has not been prepared, no?
No.
This is a matter after the vacation.
Obliged.
Right. This is a jail appeal against the impugned judgment dated 9/5/2023 passed by the Sessions Judge Navang in Sessions bracket T1, T-1. That was case number 03 bracket N of 2014, by which the appellant has been convicted under section 302 IP3. Ms. S.H. Bora accepts appeals on behalf of the state. Admit the appeal, call for the LCR. List the matter after 4 weeks.
Lordship, Amicus curiae may be appointed. Mr. M.S. Laskar is present.
Okay, Mr. M.H. Dakhtar is appointed as the amicus curiae in this case. This is the matter after 4. Jail appeal again.
Yes, Lordship.
There is a jail appeal against the judgment dated 17/7/2023 passed by the special judge bracket Pokso, Karbi Anglong Difu. In Pokso case number 27 of 2022, by which the appellant has been convicted under section 6 of the Pokso Act. Issue notice returnable in. No, you wait. Issue notice returnable in 4 weeks. Ms. S.H. Bora, additional PP accept notice on behalf of the state. And before that, before issue notice, right, admit the appeal, call for the LCR. Then right, issue notice. S.H. Bora accept notice on behalf of the state. Registry shall issue a notice to
Here also, Amicus curiae has to be appointed.
the victim / guardian of the victim / informant. Pustak. As the case pertains to Bokajan PF case number 80/2022 under section 376 IPC read with section 6 of the POCSO Act, registry will furnish a soft copy of the appeal petition to Ms. S.H. Bora, additional PP, who shall transmit the same to the OC of the concerned police station. The OC of the concerned police station shall thereafter give a report with regard to service of the same to the victim / guardian of the victim / informant. This is the matter. Oh, who do it?
Amicus curiae.
Oh,
Lordship, there is a big
22. By which the appellant has been convicted under section 498A, 323, 457, and 326 bracket capital A IPC. He has also been convicted under section 4.
Yes, ma'am.
for the
Four of the
Dowry
Dowry Prohibition
Prohibition Act.
Admit the appeal, call for the LCR. Miss S.H. Bora, accept notice on behalf of the state. Appellant to take steps for service of notice upon the respondent number two
Yes, ma'am.
by registered post with dated within the course of the day. Within the course of the day. This is the matter of the
Obliged.
May I present your lordship?
notice.
This is statutory appeal. Appellant convicted under section 4 clause 2 of POCSO for 20 years of imprisonment. At this stage, appeal may be admitted. Lordship. Adjourn may be called for.
Supplementary.
Correct. Right, Miss
Ardeka.
R. Deka appearing on behalf of
HR.
H.R.A. Chowdhury. Counsel for the appellant. This is an appeal against the judgment dated
211.
2/11/2023 passed by the additional sessions judge cum special judge bracket POCSO
Okay.
at Barpeta in special POCSO case number 126 of 2020, by which the appellant has been convicted
For 20 years.
under section 4 bracket 2 of the POCSO Act.
Yes.
Admit the appeal, call for the LCR, issue notice returnable in 4 weeks. Ms. S.H. Bora, addition PP, accept notice on behalf of the state. Appellant takes steps for service of notice upon the respondent number 2 by registered post within the course of the day. In the course of the day. This is the matter of the phone. Then. Right. Ms. S.H. Bora, learned APP is run in 4 weeks' time. To file written objection to the application under section 89.
Next.
So this can be listed for hearing.
Lordship.
Have you received the paper book?
Yes, paper book is ready, Lordship.
Ms. S.H. Bora, learned APP submits that she has received a copy of the paper book. Though no one appears for the appellant. comma, Office note dated 11/10/2018 states that paper book has been furnished to the learned Amicus curiae. Accordingly, this is matter for hearing in usual court.
Lordship, may I submit, Lordship? Here also, Lordship, name of the amicus curiae is not given in the cosmos, Lordship.
Oh. Registry to list the name of the Amicus curiae, Mr. Bikash. Mr. Bikash Prasad. In the Congress.
Lordship.
Item 6.
Have you received the paper book?
Yes, ma'am.
You have received, you have got it also, madam?
Lordship,
Let us see what the office note says.
Lordship.
This is. Here, my lord.
Paper book has been furnished upon Miss B. Buyan, learned APP.
Yes, this is absent today, Lordship.
Okay, right. Mr.
EM Children.
B.M. Chowdhury submits that he has received a copy of the paper book. Puस्तक. Office note dated 19/8/23 states that paper book has been furnished to Miss B. Buyan, learned APP. So accordingly, this is matter for hearing in video.
My lord, here is an IA, my lord.
Okay, we
I
can
have-
hear the I. What is the I?
I, my lord, for releasing the, my lord, the appellant from the.
And wait. Now let us see what is your case for wait.
My lord.
Any eyewitness?
My lord, eyewitnesses statement, my lord, 3 witnesses have been turned hostile, my lord. They have stated, my lord, the names of the, my lord, some stated about 3 appellants, my lord, assaulting, and another, my lord, 4. But, my lord, learned trial court, my lord, relying on some, my lord, circumstantial evidence. As per the, my lord, the trial court, the case rests on circumstantial evidence. No eyewitness. Here, my lord, 5 accused that faced trial, my lord. Only the, my lord, this appellant has been convicted under section 30.
Yes, madam.
Yes, Lordship. Since the report is not with us, just now I have taken from my learned friend, Lordship, I have to go through it.
And this is a case, my lord, where evidence of the hostile witnesses, this, my lord, 3-4 person assault. But
Huh?
3 and public 4, my lord, accused persons, they had assaulted. With the, my lord, the same set of, my lord, evidence, others were left out, my lord, only considering some of the circumstances he was convicted,
You were the one who took him to hospital.
my lord.
You were the one who took him to the hospital.
Yes, he took him to the hospital.
What to do, madam? Huh? evidence, this matter is not listed.
Not restricted.
I think the IA is not listed today. That's what I'm finding. Huh?
It is listed along with the.
Along with the appeal.
Appeal, Lordship.
No, it only says criminal appeal. It does not say IA. You get the cause list?
Yes.
I have not been so.
Huh? It is not shown in the cause list.
Not
but it
shown
is
in the
about-
cause list, madam.
Yes,
Madam, there's no evidence against this person.
Lordship.
It appears there's nothing against the person. And those witnesses have turned hostile.
Lordship.
Now let us see the hostile witnesses, what
My
are they
lord.
said.
PW 10, my lord. PW 10 at page 25, my lord, of the paper book.
Oh, there was slapping, punching and kicking.
Yes.
That is the evidence, and that is by my lord, not only by this appellant, my lord. Hostile part of the my lord, lordship will find, my lord, what they had stated to police. Here is my lord, Babu Saikia, Basanta Saikia, and Min Raskua were slapping, punching, and kicking the.
So the
abundance-
other two persons have been acquitted over.
Yes. One, my lord, Basanta Saikia has been acquitted. Min Raskua, my lord, he was a juvenile. He was tried by the juvenile court. And my lord, Okonman Raskua also, my lord, he also slapped that person. He also acquitted, my lord. Same set of evidence, my lord. Only P can choose basis, my lord. He was, my lord.
What did the learned trap court, why did the learned trap
Yes,
court
ma'am.
only pick you?
Lordship will find it from para 32, my lord.
Page?
Page 119.
Yes.
Lordship will find. First, my lord, at page 25, my lord, it has para 25. It has come to the, my lord. Page 25 at page 115, my lord.
Yes.
On careful scrutiny of the above evidence on record, it is seen that the whole prosecution case primarily rests on circumstantial evidence. In a case based on circumstances settled in that circle from which the conclusion of guilt is drawn should be fully proved, and such circumstances must be conclusive in nature. Moreover, all the circumstances should be complete, forming a chain, and there should be no gap left in the chain of evidence. Further, the proved circumstances must be consistent only with the hypothesis of the guilt of the accused, my lord. Then, my lord, para 31, my lord, at page 119.
Yes.
It is seen that PW to depose that accused Babu Saikia, called PW to the place where Nandesar was found, groaning due to his pain. It shows that he was assaulted so badly before PW to reach that place that he was unable to speak. At that time, accused Babu called him when injured, since deceased was fighting for last breath for his life. Though defense side tried to point out in the course of examination of PW2 that in his statement, Exhibit 1 recorded under Section 164 CRPC, he did not state that Babu Saikia called him over phone to the place of occurrence, but the fact remains that had he not been called in the odd hours of very early morning in the winter season, there was no reason for PW to come to the spot where Nandesar was lying in injured condition. Then, my lord, I am on section 3, my lord. In this connection, if we see the evidence of hostile witness, Sri Makhan Raskwa PW10, then it is seen from his hostile part of statement that on 9/11/2011 at about 6:37 p.m., he saw accused Babu Saikia, this is present appellant, my lord, Vasanta Saikia and others were also assaulting one unknown person. Then, my lord, similarly, the other hostile witnesses, my lord, para 34 and 35, my lord. Similar sort of evidence has been given by the witness Srimati Sampa Raskwa, who is the wife of the accused Okonman Raskwa. She was also declared hostile as per prayer of the learned PP. PW 11.
Same evidence, why some have been acquitted,
Lordship.
some have been let off. Okay, right. In the IA, huh? Heard, Mr.
BM Chaudhary.
B.F. Chaudhary, learned counsel for the applicant. Also heard Ms. S.H. Bora, learned APP. This application under section 389 CRPC is for suspending the sentence imposed upon the applicant appellant who has been convicted under section 302
Yes, my
IPC
lord. 302.
in pursuant to the judgment
Order
dated 23/6/22,
23/6/2022.
23/6/22 passed by the learned Sessions Judge Golagar in Sessions Case number 173/2014 arising out of GR case number 241/2011. The counsel for the applicant has. Yes, what? No. You tell them to make a separate list. Supplementary list for this IA. Okay, just tell them to me. Let them make a supplementary list for this IA. Otherwise. The counsel for the applicant submits that though the evidence of the hostile with the evidence that though the evidence of the hostile witnesses shows that in their statements made under 161 CRPC, the applicant along with page
Basanta Saikia
Basanta Saikia
and Min Raskwa
and Min Rajkhoa
and one Okonman, my lord, Raskwa.
and one Akanman Rajkhoa had been seen to be slapping and hitting the deceased with a lathi, comma. Only the applicant has been convicted. He also submits that there is no evidence recorded by the learned trial court to show that it was to show that the applicant had caused the death of the action of the applicant had caused the death of the deceased. That's all?
Yes, my lord.
Lordship. Otherwise, other accused persons have been released on acquitted.
Ah.
So might be on the same footing, Lordship.
Miss S.H. Bora, learned APP submits that. What will we say? Submits that? The learned trial court having
Objection because it is.
having found the applicant guilty after going through the testimony of the witnesses.
Yeah.
comma, there is no ground to suspend the sentence or release the applicant on bail. What do you want to say? That
Otherwise, I have objection because his 302 is there, Lordship.
Caesar, but no, Caesar is there, but
Yeah.
there has to objection per se can be there.
Yes.
But what is the basis for the objection? That's what I'm asking you. What is the basis for the objection? He's saying
Lordship.
that 3-4 persons were found slapping this person.
Yes. And
That is also 161. It is not evident
Lordship.
because they have been
Otherwise.
declared hostile.
Yes.
Okay, so even if we accept that part of the evidence,
Lordship.
that 3-4 persons had been slapping the deceased.
Yes.
Now, why should only the applicant
Yes.
be put to blame?
Otherwise, no specific reason is given to the accused person, just he is the only culprit.
And if you look at the evidence, there was no weapon as such.
Yes, only slapping and.
Slapping
feasting
and fisting and
blowing,
whatnot,
etc.
and if
Yes.
there also, I don't know why they use the word fisting. There's no word as fisting. They're hitting him.
Yes.
Boxing him, hitting him, no fisting. So what have you got to say to that?
Moksha, where's your lawsuit?
Let us see what are the evidence of the medical doctor?
At page 57 of appeal letter.
31, 32 is the my lord Dr. Rupak Bora.
Page?
Page 31, 32, my lord.
In my petition, it's 57.
Paper book, my lord.
Yes, sir.
Dr. Rupak Bora, PW 30.
At page 31.
Lacerately torn over right face. Abrasion over both soldiers, multiple bruises over back of chest. Abrasion over left forearm and multiple bruises over both hands.
We have heard the learned causes for the parties. On considering the fact that the 161 statements, 161 CRPC statements made by the hostile witness
Lordship, may I submit in the medical report, Lordship? It has stated that, as per the opinion of the doctor, the cause of death was due to shock and hemorrhage as a result of head injuries sustained by the deceased. Injuries were caused by heavy blunt weapon. That was lathi was used at
Lathi was-
relevant point of time.
but used by whom?
That is not
That
there.
is not
That is
clear and specific. Otherwise, it is probably a mob attack.
Does the trial court say that the applicant had used the lathi? No.
That part in the case, paper
Whatever
which
I
is not the case.
Show that the applicant, comma, Basant, what?
Babu Sakia, my lord applicant.
No. Show that Babu Saikya, the applicant is Babu Saikya. Who's the other person?
Vasanta Sakia,
Basanta Saikya,
Min Raskwa,
Min Rajkhawa, and
and Okanman
Ankanman Rajkhawa were found to have been slapping and hitting the deceased along with an assault through a lathi. Comma. Only the applicant has been convicted by the learned trial court. System. There is no other evidence recorded by the learned trial court except the questions, except the question put to the hostile witnesses. Comma, that is PW
PW, my lord, 10, 11, and 12.
10, 11, and 12. With regard to what they had stated to the police regarding the perpetrators of the assault on the deceased. On considering the above, comma, we are of the view that the sentence awarded to the applicant should be suspended for the time. And the applicant released on it. Accordingly, the sentence is suspended and the applicant is released on a bail bond of rupees 50,000. 50,000 with one surety of life amount to the satisfaction of the learned trial court. The IA is accordingly disposed of.
Mobilization.
May please, Your Lordship. Your Lordship, the arguing counsel is not keeping well, so he is absent today. Your Lordship, the matter may be adjourned with a short date. Your Lordship.
Only that whether they will be filing an objection or not.
Your Lordship, by next date, you will file, Your Lordship. On
When?
delivering instruction with.
Huh?
Mr. D will sign, Your Lordship.
You'll find objection when? Within,
Within 19, Your Lordship.
by 19.
Yes.
Okay, Mr.
I.H. Laskar on behalf of the.
Wait, Mr. R.K.D. Chaudhary, D. Deputy SGI appears for the appellant. Mr.
I.H. Laskar on behalf
I.H. Laskar appears on behalf of
D will sign.
DUC. Learned counsel for the respondent numbers 1 and 2 and submits that Mr. DUC is unwell and prays for adjournment.
Yes, Lordship.
He also submits that written objection will be filed by the respondent on or before 19/1/2023. Accordingly, this is matter.
One more thing, Your Lordship, the copy of has not been furnished, Your Lordship.
Lordship, they have been served. Lordship. After that, they have
Incomplete copy, Your Lordship.
All right, Lordship, it's not incomplete, Lordship. My learned friend says so, I will supply a copy today itself.
Accordingly, this matter. When after
Can it be, Lordship, in the first week or second week of February, Lordship?
in the matter in the second week of February. 6th February.
Kind of language.
19th is just next week.
Yes, Lordship.
Phone number.
May I please, Your Honor? It's a POCSO matter of conviction of 15 years under section 4.
So
Whether
notice
it-
will have to be, notice will have to go.
Yes, to the respondent victim.
Now what to do? They are legally counsel, no?
Yes, Your Honor.
Lordship, through registry, Lordship, they will provide us a copy.
Okay, right. This matter pertains to the conviction of the appellant under section 4 of the POCSO Act.
Ali, Habibullah Zaman, Alshan, Walim, and Soleiman. I'm not there following him. When Zahar Ali reached in front of the house, the accused person who followed Zahar Ali caught hold of him. After catching Zahar Ali, accused Syed Ali had struck him with a dao. Another accused, Habi, has struck Zahar for a long knife. Both the accused person had hit the victim on his head. As a result of the victim fell down on the ground. The other person, Hassan Ali, Jamil Ali, Solomon Ali, etc., had assaulted and hit the victim with sharp weapon. As a result of such assault and hitting by sharp weapon, the victim, Zahar Ali, breathed his last. He died on the spot. Now, my lord will kindly come to the IO's evidence, my lord, with regard to proving of this particular fact, whether he has stated in his previous statement. That is, my lord will kindly come to PW 13, my lord. 13, no? 13, yes. Altogether defined. I am not been implicated, my lord. 13, my lord. Where is the place of occurrence? As per Azahar, the entire incident took place in presence of Hassan Ali and Habibur Rahman. Both were the only eyewitness of the occurrence. PW5, Rahimullah, PW6, so and so are resident of so and so village. The incident occurred in jute cultivated land and no any house near the place of occurrence. There was no house in jute field. The dead body of Zohur Ali was found in the river Champa. The upper portion of the dead body of the deceased Zohur Ali was found. The informant identified the dead body so and so on the basis of so and so. I could not identify the dead body whether the deceased was Hindu, Muslim, etc. The occurrence took place on so and so date, and the inquest of the dead body was done on 23/6. The viscera of the deceased was not sent for SFP, so and so, so and so. So, as been projected by PW5 and PW6, places of occurrence totally different. It's in the market, or whereas it is in the paddy field. As for the PW1, information has been gathered from PW5 and PW6. And PW5 and PW6, my lord, never stated my name. And as such, my name doesn't appear in the FIR. One Hassan Ali is there, the father is different. Under these circumstances, I am before this honorable court. And the prosecution has filed their objection with regard to 5, 6, 8, and 11. 8 and 11, my lord, 8 doesn't even whisper both of the appellant's name. If your lordship comes to PW8 now. I know the complainant, I know the accused person, I know the deceased person. The incident occurred 10, 12 years ago. The incident occurred at 4:30. On the date of occurrence of the incident, I heard hue and cry in the location. I saw the people were running so and so. I went to the exact place from where cry took place. The incident occurred near the river side of so and so. I went to the place and saw the assailants were assaulting Zahar Ali and Saran. After assaulting, went to a boat. The assailants 10 to 15 in numbers. Many people gathered at the place of Zahar Ali and Saran Ali succumbed to their injury. The accused persons could not be held by people. I did not see those assailants in the court today. These were not the persons. And 11, my lord, will kindly come to 11. There is an omnibus statement in PW11. That is Shah Alam Sheikh. I know the complainant, I know the accused persons who are present today in the court. I know the deceased victim, namely Sahar Ali and Jahar Ali, were the brothers of the complainant. The alleged incident occurred about 16, 17 years ago. The alleged incident occurred in the afternoon hours. At the particular place of occurrence of the incident, I came back home from paddy field. After some time, I heard hue and cry near my house. When I went out, I saw Jahar Ali was running and all the accused persons were seizing him from behind. The accused person fought Jahar Ali, who fell down on the ground. Accused Saad Ali had assaulted and hit Jahar Ali by way down on the shoulder. Thereafter, the accused person assaulted and hit Jahar Ali by dagger and deadly sharp weapon. There was profuse bleeding oozing out from the body of Jahar Ali. As a result to such assault and hitting, Jahar Ali died immediately on the spot. I also saw a pistol in the hand of Saad Ali. Thereafter, all the accused person dragged the dead body of Jahar Ali towards the river so and so. And other accused persons, who is also the brother of Zahar Ali. Zahar Ali was murdered prior to murder of Jahar Ali. On the same day, I came to know that the accused persons had killed Zahar Ali, who was the brother of Zahar. The accused person also had killed both the deceased, one after another. I saw entire incident of murder of Zahar Ali. After killing Zahar Ali, the accused person had left the place along with the dead body of the deceased. After watching the entire incident, I came back to my house out of fear. Police arrived at the place of occurrence. I was taken by police for inquiry. Police recorded my statement. I also told police about the same incident that I have deposed today. Not been named itself. All the accused person, and so my lord comes in my lord. No specific overtake, whether their presence itself was there, nothing is there. That is the quality of evidence. So for Akhar Ali is concerned, the father, my lord, 72 years, he has not been named in the affair. At first point of time. Under these considerations, my lord, I am before your lordship, praying with folded hands for granting bail money.
Yeah.
That is my resolution.
Even stated copy of FIR, my lord, stated copy of FIR. And one just short note, my lord. Your lordship. It is IA number, my lord, 606. Item 14. Criminal appeal 254. 254. 3 persons, your lordship. Now, your lordship, can see FIR, my lord, English copy I have given, your lordship. 12% name in the FIR. And you look and see the respective to state that on 21/6 at 4:30 PM in the evening, when my two brothers, namely Sohagadi and Johagadi, were returning home after marketing at Chapar Bazaar, along with Muhammad Hussain Ali, son of Afzal Sheikh of same village, on reaching the back side of the southern part of the house of the accused number 5 at Sandipara village, suddenly the accused number 3 is my Said Ali Sheikh. Shot my brother Shahid Ali with a pistol from backside. Pistol is neither recovered nor anything is there in the pistol, my lord. When my brother started running after sustaining bullet injuries, immediately other accused who were hiding nearby the jute and paddy cultivation came out, and as per direction of the accused number 1, Hussain Ali killed Shah Ali, just how my learned friend has mentioned, my lord. Hussain Ali killed Shah Ali by sharp weapon. At the time of occurrence, my brother Johar Ali started running to save himself, but accused killed him also mercilessly by sharp weapon. While searching the bodies of my two deceased brothers, one headless body was recovered at a distance nearby the river. One Muhammad Hashim Ali was accompanying with my two brothers. Somehow fled away and informed me about the incident. Accordingly, after repeated searches, the headless pieces of the bodies were recovered from the water nearby river. From the wearing apparels and two hands, it is identified as the body of my deceased brother Johar Ali. The body of my deceased brother Johar Ali is not yet found. Due to searching, there is a detail. So here, my lord, a specific name is there in the FIR as per FIR, accused number 3. The specific, my lord, accused number 3 and accused number 1. Now you will have to kindly see, my lord. To tell, my lord, I have given just a short note, my lord, 2-3 pages. Just I have given your lordship will find. A brief.
Your client is Lalchan Ali.
Lalchan Ali, 3 persons, my lord. Lalchan, Wahab, and Jamal. Lalchan, Wahab, and Jamal.
No, but those names are not here today. Today only Lalchan Ali is here.
No, my lord.
Who else?
3 persons filed this.
Acha, and two others.
IA number 606.
Wahab and Jamal.
Yeah, Wahab and Jamal. Now, there is no specific matter, no rule has been attributed to this person. And even your lordship kindly see the whole case is that matter, this two dead body is not identified even matter. Assuming that they are presence will not do matter.
There must be some override.
This Lalchand, is it Lalchand? No.
Yes, Lalchand in the FIR, my lord, his name appears at 9.
So his name is Lalchand or Nalchand?
Lal L-A.
LL.
L-A.
Lalchand is also mentioned.
Yes. Name like that in the FIR, man. Yes, PW2 your last can is independent witness, PW2 man. What is it? PW2 man. He is Hashem Ali. As per my lord informant, he was there present along with them, he was kind of that I'm reading my page, that is cross my lord. The distance from Kashmiri village to Chapor is about 6 to 5 kilometers away. To reach, so I came to Kasri to prove I can engage boat. When we landed at Put Chandipari by engine fitted boat, then myself and the deceased persons went to their destination on different roads on foot. You look a very important, independent witness. I came to my village by different roads, and Shaharali and Zaharali went through different roads. Later on, after 2-3 hours, I came to know your lordship. Your lordship got him a period 2 months. So very important. Only independent witness. Rest of my lord, they are this those 2 persons from coming from the jail who were convicted in a case filed by our party, my lord. Now, what he says, my lord, at the relevant point of time, so I came to know that some unidentified person had killed Sohar Ali and Johar Ali, unidentified person. At the relevant time of the incident, there was a riot between Santal and Boros, and for the said riot, several bodies were found dead near the Champa River. After the incident, I did not meet the complainant Mohar Ali. Your lordship, very important man. He said that this person told him. That this person said, I have not met after the incident. I have never met that Mohar Ali man. After 2-3 days, a dead body was recovered, which was not identified by the police. Later on, many people said that the dead body may belong to either the Podo or the Santal. But here at that particular time, my lord, there is a riot between Podo and Santals, by the Adivasis. Several dead bodies were there in the river, my lord. And the defense cases that these dead bodies may belong to those people, my lord. It is not belong to this Sahagari of the Jordan. This is a specific case, my lord. And this is supported by PW2, my lord, independent witness. Later on, many people said that the dead bodies may belong to so and so, so and so. The deceased Johari and Sohagari were having enmity, your lordship, to lots of people of our village. So, after 10 to 12 days from the date of the incident, police took me to the magistrate for recording my statement. I did not state before the magistrate as per instruction of the police. The statement recorded under section 164 was not read over and explained to me. I cannot say or understand the Assamese language properly. Police had treated me to depose as per their instruction. Otherwise, I was threatened to be one of the accused along with them. The magistrate did not explain me that he was judicial magistrate and he is going to record the statement. In the place of occurrence, there was only a house which belonged to Makbul, and there was jute field up to 3-4 kilometers from the house of Makbul. The house of Iman Ali is located near about 3 kilometers away from the place of occurrence. The house of Javed Ali, Abu Ahmad, Jahuruddin also 3 kilometers away from the place of occurrence. I heard that Jahuruddin was involved in an offense for which he was convicted. The house of Rahimuddin and Shah Alam are also 3 kilometers away from the place of occurrence. I also heard that Rahimuddin and Shah Alam are also convicted in the all. Now, period of 5 and 6, they were convicted, but they were acquitted by the court below. Came to the High Court. High Court convicted them. And they were in the custody. They came from jail and they have, my lord, just your lordship, same type of evidence they have given 5 and 6. And there also these 3 petitioners, not no special at all. These 3 petitioners. Only Said Ali and some other 2-3 persons. Not a whisper against that this person had done this thing or that. That is not there. General statement. Kindly for 5 and 6. My lord, they have based their conviction on 5, 6, 11, 12, and 15. They say the IU test, but period 2 is very important. Just now I have read, my lord, period 2. Now your lord kindly see page 5 and 6. Sorry, period 5 and 6. 5, he was, your lord kindly see 5, cause, first line. Today I have come to depose before the court from Dubri jail, as I am languishing in the murder case of Hassan President. Hassan President belongs to this different accused group. Of course, we have nothing to do with it. We are not relative to Hassan group. So, same thing, he said, my lord, PW6, you also will find PW6. He also, same thing, my lord. Today I have come from the jail and I am deposing. So, same thing. 5 and 6. Then you also will find 11. They have relied, my lord. 11. 11 is son of PW6. Son of PW6. And he also, you'll also kindly see, not especially nothing. 11 also says, I saw that Johar Ali was running and all the other accused persons were chasing him from behind. Then your lordship, they have relied on 12. 12, your lordship will find, 12 is Shakar Ali. He is also, my lord, Shakar Ali. 12 is, your lord, Shakar Ali, son of deceased Shahar Ali. He also interested, son. He also did not name this present petitioner's wife. Then you also will find 15. Last they have, my lord, they have relied on 15. 15 is the, my lord, your lordship, son of own, my lord, the own nephew of the deceased, own nephew of the deceased. And 13, my lord, Ayo, your lord, very important, Ayo is, my lord, 13. 13 says, my lord, as per Azhar, the entire incident occurred in presence of Hassan Ali and Habibur Rahman. The what they said, what is the deposition? They also did not take, no whisper against the present petitioner. Both were the only eyewitness of the occurrence. IO is saying that. They are not saying anything. They are bringing somebody from the jail who are the relatives of those persons and just stereotype might have they have given that. PW6, the incident occurred in a jute cultivation land and no any house near the place of occurrence. The dead body of Johar Ali was found in the river Champa. Should I continue, my lord?
Yes, yes. Continue.
Yes. Yes. Your lordship has gone through it, my learned friends elaborately yesterday also. So your kindness about page 13, PW 13, IO. Where is the case? I do not find what is the basis of conviction. Riot took place by Adivashi and Boros, that dead bodies are there. IO is saying, many of the witnesses they are saying, whose dead body those two were, my lord. Now, your lordship, page 13, sorry, PW 13, my lord. Just I have read, my lord. That only eyewitness as per PW 13 is my lord Hassan Ali and Habibur Rahman. Hassan Ali and Habibur Rahman. And Hassan Ali and Habibur Rahman means, my lord, Hassan Ali is PW 2. Your lordship kindly say PW 2. And Habibur Rahman. Habibur Rahman is, your lordship, he is not, my lord, he is not witness. He has not deposed. So only, my lord, police say that, my lord, Habibur Rahman, Hassan Ali and Habibur Rahman, both are the only eyewitness of the occurrence. Very important, my lord. And period 5, Rahimuddin Sheikh Jahuddin are the residents of so and so. Incident occurred in a jute cultivation that I have read, my lord. Apart from the dead body of the deceased Johar Ali was found, the informant identified the dead body of the Johar Ali on the basis of best. I could not identify the dead body, whether the deceased was Hindu, Muslim, etc. The occurrence took place, your lordship, 21/6/99, and the inquest of the dead body was conducted on 23/6/99. The viscera of deceased were sent to FSL for examination and not for identification of the deceased. Not for identification of the deceased. That is more important, my lord. How they can say, my lord, these are Johar Ali or Shohar Ali, my lord. It is not a fact that at the time there was communal riots. Your lordship, very important. Communal riots between Borders and Adivashi, and many dead bodies of the Boro and the Adivashi were found in Champa River. It is not a fact that the exhibit 6 is not the inquest of the dead body so and so. It is not a fact that, yes, I am skipping, my lord. Then, my lord, PW1, Mohar Ali did not state before me that Hashem Ali, Rahimuddin and Jaharuddin informed him regarding the incident. I only recovered the dead body of the Johar Ali. PW5, Rahimuddin did not state before me that he saw the accused person running behind the deceased and then caught hold of the deceased and thereafter killed him. He did not state before me that the accused Said Ali assaulted and deceased with Becky Rao. He did not mention that Hassan Ali Suleiman directed the other accused to kill the deceased. So that also gone. Then where is the evidence, my lord? I did not record the statement of Shukur Ali. He is the only seizure witness. No any pistol, revolver was seized from the place of occurrence. It is their case that might have shot by the pistol he was might have killed. It is not a fact that I did not seize the material exhibit from the house of the accused. It is not a fact that the accused persons are not involved in the instant case and the seizure articles do not relate to the accused person. I did not submit that to the report. Where is the case? Yes. Yeah, Dr. The main matter IO is saying only 2 persons are eyewitnesses. One of them is examined, other was not examined by him. Yeah. PW7. Yes. Yes, PW7. On 26, I was posted as medical officer so and so. I conducted post-mortem examination of deceased Shahadi of village so and so with reference to Chapel PSK. The dead body was brought by one constable Jogandar. Who had identified the dead body? Who is he to identify matter? How he cannot say the name is Sohagari or Johagari. He may simply bring the body, my lord. He cannot identify. Then, my lord, was brought by one constable. I conducted the post-mortem examination on the same day on the police requisition. During examination, I found the following. Your lordship kindly see the nature of the injury and the statement to have given. Ocular evidence and the medical evidence. Nine. 10 person, my lord, all the person killed, no injury. So ocular evidence and the quite different from the medical evidence. No. There are specific case had no injury.
Anybody else? In any other case?
So our minor cases, my lord, not at all, no whisper against these persons. None of the minor reports except 5 and 6.
Right.
Even 5 and 6 who did not make any esprit activity against me, my lord. Huh? Oh, after the map, please. Huh? Oh, my lord, item number 8 on the same footing, no?
Witness number 8.
Oh, yes, with number 8 also, they have not seen it, my lord. But the person who has not supported the land trial court did not consider those evidence, my lord. Only that is the minor. Main witness have been minor ignored.
You are in 606, correct?
Yes. I'm in 606.
Any other? Yes.
Item number, your lordships,
Minor, may I read my lord?
IA number 614 lordships.
Huh?
IA number 614 lordships.
614. Yes.
In criminal appeal number
You are
258.
the one who shot.
Yes, lordships.
You are the one who shot the.
No, lordships.
Huh?
I am the
Yes, Shahid Ali.
Sahed Ali, Habibur Rahman, Jamal Ali Sheikh lordships. Accused serial number 5, 6, and 10 lordships. Accused number, your lordship. Accused number 5, 6, and 10 lordships. Sahed Ali, Habibur Rahman, Jamal Ali Sheikh lordships. I'm adopting the arguments led by the senior counsel lordships and including lordships the evidence of the PW number 8 lordships. PW number 8 lordships is the important lordships. Married lordships. I know the complainant. I also know the accused person. I know the deceased person. The incident occurred about 10-12 days ago. The incident occurred at about 4:30 p.m. On the date of the occurrence of the incident, I heard hue and cry of our localities. I saw the people were running here and there. I went to extract place of from where hue and cry took place. The incident occurred near the riverside of River Champa. I went to that place and saw that some assailants were assaulting Johar and Johar Ali. After assault, the assailants went by a boat. The assailants were 10-15 minutes. Many people gathered about the place of PO, Johar Ali and Johar Ali. Succumbed to their injuries, the accused persons could not be held by people. I did not those assailants in the court today. Police asked me about the incident. I know this much only. This is the very important witness, the PW number 8 lordship and PW 9 lordship. It is the important lordship. May I read lordships? PW number. I know the complainant and the accused person. I know the accused deceased person who died in an accident. The incident occurred about 15 years ago. On the date of the occurrence of the incident, I was at the supermarket. I come to know that Johar Ali and Sohar Ali were killed by some assailants. I came to the place of occurrence, but I did not find the deceased at the place of occurrence. On the date of the occurrence of the incident, deceased Johar and Johar Ali also went to the market. However, they returned early. In the evening, they were killed. And other lordships, we have adopted the arguments led by my senior counsel, H.S. Solita and Anand.
Yes.
May it please your lordship. My lord, I am appearing on behalf of applicant, my lord, Izzat Ali, my lord, who was accused number 6 in the FIR and my lord, accused number 4 in the impugned judgment, my lord. If your lordship allows me an opportunity, my lord, to give a brief outline of the general arguments, my lord, then I'll come to my individual arguments. So, my lord, as per the FIR, my lord, on 21/6/1999, my lord, at around 4 to 4:30 p.m., my lord, when the deceased Sohar Ali and Johar Ali they were returning from the supermarket accompanied by one Hasem Ali, my lord. At the near the house of accused Maqbul Sheikh, my lord, they were allegedly sorted by accused Said Ali. And the remaining accused persons who were hiding in the jute field, my lord, they came up, my lord, and they assaulted and killed Sohar Ali. And after that, my lord, they chased and also murdered Johar Ali, my lord. That is the main allegation, my lord. Now, if your lordship will see, this Hasem Ali, who accompanied the deceased, my lord, he was examined as PW2, and as your lordship has already seen, my lord, he never corroborated the story of the prosecution, my lord. Hasem Ali, my lord, he says that he did not know the accused persons but knew the deceased Sohar Ali and Johar Ali. On the day of the incident, PW2 along with deceased Sohar and Johar went to the market. Then he, in his cross-examination, he says that they had landed at Put Chandipar by engine fitted boat. And the deceased and this Hasem Ali, they had gone to their respective villages by different roads on foot. And only after 2-3 hours, he came to know that these some unidentified persons had killed Sohar Ali and Johar Ali. And he also says that he had not met the informant Mohar Ali till the next 2-3 days, my lord. Now, my lord, if your lordship would see, the learned court below relied on the evidence of PW5, PW6, PW11, PW12, and PW15, whom this learned court below considered as eyewitness, my lord. But there are several contradictions among these witnesses, my lord, which we believe, my lord, that the learned court below did not consider, my lord. Now, my lord, the first point is that, my lord, who had accompanied the deceased on their way back from Chapor Market, my lord. If your lordship sees the evidence of PW12 and PW15, both of them have claimed that they had accompanied this deceased. However, my lord, their statements, my lord, are not supported by the other witnesses, that is PW5 and PW6. PW5 and PW6, who are also, as per the learned court below, eyewitnesses, they never said that they had seen PW12 and PW15 at the place of occurrence. And most importantly, my lord, regarding the evidence of PW15, PW15 says that he was accompanying the deceased along with Hasem, Sakir, and Abu Ansar. Now, Hasem was already examined as PW2 and Abu Ansar was examined as PW3. But they never said that they had seen either PW12 or PW15. They, in their evidence, never said that they, at the time of their journey from Chapor Market, they were accompanying the deceased. So this part of the statement does not get any support or corroboration from the evidence of either PW3 and PW2. The next point which will arise is whether PW5 and PW6 were actually eyewitnesses, my lord. If your lordship will see, this PW5 and PW6 were actually interested witnesses, my lord. Because, my lord, at that point of time when they were examined as witnesses, my lord, they were facing charges for murdering accused number 1, Hassan Ali. If your lordship will see the FIR, my lord, the first accused, Hassan Ali, he is the person, my lord, who was allegedly murdered by this Rohimuddin and Johiruddin, my lord. However, my lord, the learned court below, relying on the evidence of DWs, came to a finding that just because they were acquitted by the Honorable Supreme Court, that means they were not interested witnesses. However, my lord, at the time when these witnesses, my lord, were examined, the case against them will still continue in the High Court. And, my lord, regarding the evidence of PW5 and PW6, whether they were actually eyewitnesses, my lord, if the lordship will see the cross-examination of PW8 Monwara Khatun, who in her cross-examination, my lord, she admitted that Johiruddin and Rohimuddin were not present at the place of occurrence at the time of incident. That is a clear statement in the cross-examination of PW8. Even, my lord, PW9 Somer Ali, he in his cross-examination, he also admitted that he, along with Johiruddin, Rohimuddin, and Abdul Jalil, had come to Chapor Market. After hearing about the killing of Sohar Ali and Johar Ali, they came to the
So
place of
Izzat Ali's name is not mentioned anywhere, is
No.
it? Huh?
Izzat Ali's, my lord, regarding the incriminating allegation against Izzat Ali. The only thing is that, my lord, one wooden dagger was allegedly recovered from the house of Izzat Ali, my lord. And if your lordship will see.
Which witness has mentioned your name?
PW 17 and PW 19, man. If your lordship will see the evidence of PW 17, he says, I cannot say whether I put thumb impression in the scissor list or not, as the incident took place long back 20 years ago.
So where has he mentioned your name?
Man, name has not been mentioned by anybody, man. Not only the eyewitness, my lord, who were relied by the learned court below, but also, my lord, the Caesar was not proved by the Caesar witness, my lord. And the other witness, my lord, PW 19, who was also a Caesar witness, my lord, he was declared hostile. But the procedure for corroborating or challenging the evidence of hostile witness, that was not followed by
So
the
the,
learned
so
court
the
below.
dagger was found from your house.
Yes. And my lord, if your lordship will see the PW 19, my lord, after he was declared hostile, my lord, the IO was not re-examined to prove the contradiction. So, my lord, the seizure was not proved. And regarding, my lord, the
Yes.
exact allegation, my lord, whether the applicant was present or not, my lord, PW 5 and PW 6, they have named only 7 accused, my lord. Said Ali, Hobby, Jamal, Hassan, Nalsan, Akhir Ali, Mokbul, Wahab, and Soleiman. But these two witnesses also never named the applicant, my lord. And the other accused persons, my lord, the witnesses PW 11 and PW 12, my lord, though they have said that, my lord, all the accused persons were assaulting and killing Johar and Soharman, my lord, there is no specific allegation against the role of the present applicant, man.
Anything else?
But that
Yes, stood there for Mirajul Haq.
highly obliged.
What is your name?
As the
Yes, Das.
or yes, Izzat Ali.
Huh? What?
Izzat Ali. Item number 18, man.
Yes, Das. So no one appeals for Mirajul Haq. Kataki. No. Yes.
Lordship, first I'm coming to IA number 606, 2023, for the Lalsan Ali matter. Lordship, we have filed a objection in this regard. Only three things I would like to bring to the notice of your Lordship. Lordship, PW5, so Rahimuddin, who is an eyewitness, in his statement, he clearly states the name of Lalsan, Wahab, and Jamal. And Lordship, in the cross-examination part,
PW5.
PW5, Lordship,
Yes.
Rahimuddin,
Where does he mention? Jamal?
Lordship, with me, I don't have the copy.
Lal Chand Wahab. Yes, he mentioned that.
He mentioned, and in the cross-examination part also, Lordship, when as because he was also one of the convicted one in another case, and he said that he has come from the jail. And here also, the deceased one is the one some president with whom the relationship was made with 3 persons, 3 accused. But here the Lalsan, Wahab, and Jamal, these are not the persons who are the relative of that particular deceased person in that case also. Lordship, then PW6, another eyewitness, Zahiruddin, who also took the name of one Jamal, Lordship, who is also one of the petition.
So only Jamal's name is there.
Jamal name is there in PW6 statement. But in the PW5 statement, all the three, Lalsan, Wahab and Jamal, three names were there in the statement, Lordship. Now, Lordship, in PW11, Lordship,
Yes,
PW11 is Lordship Shah Alam Sheikh, Lordship.
Hmm.
Here, he deposed before the land court that he witnessed all the accused person. All the accused person.
yes,
Yes. And in the cross also, Lordship, there is no such suggestion or that he didn't deny about the same. Now, Lordship, PW7, the doctor who examined one disease, Seher Ali. Lordship, from that report also, it is very clear that there was injury in the part. And from the statement, the deposition made by the PWs, it is clear that there was an incident where the weapons were used, he was beaten. Same way, the PW20, Lordship, the doctor, another doctor who examined another disease, Zahir Ali, the same way, that it was very clear that there was an incident, the weapons were used, and along with the statements of the PWs, is corroborating with all those evidence. So Lordship, so in this matter in 606, my humble prayer before your Lordship that it is not a case where the suspension and the same time the bail is granted to all these three accused.
yes.
Lordship, next in I Criminal 614/2023, Lordship, Sahed Ali and two others. Lordship, here also PW5, Lordship, who is an eyewitness, Rahimuddin.
Yes,
Here, Lordship, they took the name of Habi and Jamal, Sayed Habi and Jamal. Now here is Sahed Ali. So Habi and Jamal in PW5.
yeah,
In the similar way, Lordship, it is the PW6, the Johiruddin, another eyewitness.
yes,
He took the name of Sayed Habi and Jamal. Here, Habi and Jamal.
yes,
Lordship, then PW11, Sahalam Sheikh, who took the name of all accused persons.
yes,
Lordship, in a similar way, PW15, this Sekhar Ali, who was the nephew of the informant, he also took the name of Jamal.
PW15 took the name of Jamal, where?
Lordship, PW15. accused Jamal given a blow to Sohar.
Now. Yes,
Lordship, and again, I'm going to the PW7, the doctor, to examine the Seher Ali and the PW20. PW7, the doctor who examines this is Seher Ali, and PW20 who examined this is Jaher Ali. So, Lordship, in these two matters, my humble submission for your Lordship, when there is eyewitness and the medical evidence also corroborating with the statement that there is some incident, weapons are used. And so, Lordship, my humble prayer is that for the ground in this class.
what about Izzat Ali?
Is that under my line of colleague CV? Next.
Lordship, here in this matter, we didn't file the written objection, Lordship.
You didn't file.
Yes, Lordship. We need some time to file.
In Izzat Ali.
Picture done.
Where is Izzat Ali's name?
Yes, only thing is that, one
Does
taker,
anyone mention his name?
is one taker with wooden handle from the house of accused Picture Dali.
So was it linked with the crime?
Lordship. Only we have, if we see the entire record and only it is come into picture whether his involvement is there. or not.
You want to see it now or what?
Later on, Lordship,
Fine.
some other day. In the meantime, we'll file the objection. Lordship.
And what about Mirajul Haq?
Mirajul Haq. Can we- Is that the- Possible. Possible, right?
Ah. So. So my sister will be writing the order. Let's see. We do not know how the order will come out.
Lordship.
So, Mr. H.R.A. Chaudhary.
Madam,
Senior
only
counsel.
that, madam, only two references, I just your lordship will see, madam. The mere presence and naming will not do, madam. But they have come, they have named all the accused, without any attributing any particular, my lord is, your lordship. So only two judgment by your lordship, and 2017 two GLT. Very elaborate judgment, my lord, it mentioned almost most of the details.
2017 to GLT
GLT 1021.
1021.
1021. And 2014 6 SCC 672.
Yes.
Just one, just I'm getting madam, Supreme Court madam. It is settled law that mere presence or association with other members alone does not per se sufficient to hold every one of them criminally liable for the offense committed by the other unless there was sufficient evidence on record to show that one such also intended to or knew the likelihood of commission of such offense. KM Ravi versus State of so and so madam. As already seen in this case, there is no legally acceptable material to prove that the applicant acted as a member of the Honorable Assembly. So our case is same thing, madam. Simple, they say all the accused.
Para.
Yes, paragraph 13. Paragraph 13, my lord, in Supreme Court case 2014 6 SCC and 2017 2 GLT, paragraph 36, 37, 38, 46.
Uh, 48 and
48, 40, 38 and 46. 36, 37, 38, 46. GLT. So basic matter for 140 they must prove that yeah, they are the member of the assembly. They knew that this will happen. Your lordship, madam, And so far 5 and 6 they are relying. 5 and 6, my lord, they are coming from the jail. Almost all same, my lord, same language they have used. And they also not made any attribute, my lord, particular attribution to the present petition, my lord. So far I am concerned, my lord. Obliged to this.
Correct. Heard Mr. H.R.A. Chaudhary, Leonard Senior Counsel for the applicants in
In
criminal and in IA criminal 606 2023. Also heard Mr. Poem Bora, who is there? Mr. P. Data appearing on behalf of the applicants in 614/2023. I have this one. Then in this is that only what to do, madam? Next, who, for Isaac Ali, who's there?
Yes, sir.
Objection may be, my objection may be recorded. Oral objection may be recorded, Lordship. Oral objection.
Correct.
Yes.
Mr.
Yes, that's fine.
S. Das appears for the applicant in IA criminal 929/2023. No one appears for the applicant appellant in IA criminal 737/2023. Then out here, the order will be passed, huh?
Yeah.
So we do not know when. Now in the main case, you're right, this is the matter after the. After,
Paperbook not prepared.
huh?
Paperbook not.
Acha, in the main case, you're right, as LCR has arrived in criminal appeal 306/2023, registry to prepare the paper, list the matter after 4 weeks.
Right, sir.
Lordship.
It is so sleepy.
May I please, your lordships? My lord, the fresh interlocutory application had been preferred, my lord. Looking into the, my lord, the serious medical condition of the appellant, my lord, who is aged about around 73 years, my lord, and serving the sentences for section 376N and section 6 of the POCSO Act, my lord. My lord, the condition has been, my lord, as referred, the medical record has also been annexed, my lord. Is a grade 3, my lord, prostate has been suffering, my lord. So he is, my lord, not in a very good condition, my lord. And my lord, till date, no objection has also been filed to the.
We can hear the entire appeal. Need to be under tension.
Lords.
Because papers have to be made, this have to be done, there will be something. No, madam, 2 o'clock. This person has killed his wife,
Yes, Lordship.
but there is no eyewitness.
The entire case is based on circumstantial evidence, Lordship. That is well proved.
Huh?
The entire case is based on circumstantial evidence, and the prosecution witnesses has proved the case is beyond all reasonable doubt that the person has killed his wife.
How?
Lordship, So I have to go through the entire, I have to submit my.
No, which is the relevant portion? How do you say
Lordship, there's a chain of circumstances.
that much too? We understand chain.
Yes.
Don't tell us the law.
Yes.
Tell us the exact evidence
Yes,
which
doctor.
which which
Yes,
clinches
yes.
the issue.
Yes, doctor.
135.
Lordship, since it is based on the entire case is based on circumstantial evidences. So first of all, I'd like to give the detail of the circumstances. Lordship. I have to go through PW five.
Anyway, since what to do? The other side is not here, madam. What to do?
Lordship.
Huh? I know, this is the
Yes, sir.
2018 matter.
Yes, doctor.
Are they
Rubzip de Lordship, Amicus curiae was.
not present last time? We'll change him. We'll change him, no point.
He may be given a class sounds, Lordship.
Why last chance? He's not come last time also. He's not come today also.
Lordship.
Today this is the only.
Let me change it.
He's not present on the last date, the date before that,
Yes, Lordship.
and then the date before that also.
Yes.
I mean, he has never been present.
Yes. Lordship may appoint any other.
Yes, right. No one appears for the appellant. Miss S. H. Bora, additional PP appears for the state. On a perusal of the orders passed by this court, it is seen that the learned Amicus curiae has never appeared before this court. On behalf of the appellant. In that view of the matter, we are of the view that some other Amicus curiae should be appointed in place of Mr. Arde. Who should we appoint?
I think there's a list of Amicus curiae, Lordship. Any name, Lordship? Hasn't been listed.
Whoever you choose, madam. Whoever you choose.
Again, B. Sharma, I know her name.
Huh?
One Bizita Sharma. Bizita.
Miss B. Sharma, Bijita Sharma is appointed as Amicus curiae in place of Mr. Arde, registry to do the needful and reflect the name of Miss B. Sharma as Amicus curiae in the cause list. Registry is also to furnish a copy of the paper book to Miss B. Sharma. Leaves the matter after.
First week of February.
Leaves the matter after 3 weeks.
Lordship.
At 2 o'clock.
At 2 o'clock. Obliged, Lordship. B. Sharma.
On this ground, we don't. Yes. Sending the same. Yes. Right. Heard, Mr. A. Datta, learned counsel for the applicant appellant.
No, I'm A. Ganguly.
A. Ganguly appearing for the applicant appellant. This is an application. Under section 389(1) CRPC for release of the applicant on temporary bail on humanitarian grounds on the death of due to the death of his father, who expired on 16/12/2023. But Shraddh is supposed to be after 13 days or something, no? What now?
Yes, but in their community, my lord, it's after 1 month.
He submits that in the community in the appellant's community, the Shraddh ceremony is to be held after a month.
Yes.
That is on 19/1/2023. 2024 post office. He accordingly prays that the applicant be released on temporary bail to enable him to attend the Shraddh ceremony. Post office. Next. Mr. K. Vaishya, LLM APP submits that he has made inquiries from which police station? From the Nalbari police station. And found that the applicant's father had expired. And accordingly, a Shraddh ceremony is to take place. He submits that he does not have any objection. Does not have any objection to grant temporary bail for 3 days, for 4 days.
Let him come out on 22nd, 2 3 days.
Huh?
Let him come out on 20, let him surrender on 22nd, till 21st, let him surrender on 22nd, Monday.
He'll come out when?
So that, maybe tomorrow. No, let him surrender on 21st or 22nd.
So release him on. I'm gonna put that. Oh, wait, 18, 19, only police protection. Only on 19,
For 1 day, man.
one day.
So that will be very difficult.
Yeah.
Because, at least, I'm not asking for a long period, but let him go for one.
But he needs to be under police protection, no?
So that is not required, but in a case of this nature. He can always report to the jurisdictional PS. This is a
He
village.
was on bail during the trial.
During trial, yes,
He was on bail.
yes. And there is no mention that I was.
Was he on bail during trial? Just look. Just give it to the PP. Just see in the record if he was on bail during trial. And let him go back on 19. Or let him go back on 19. Let him be in the 19 morning. And release on 20. And you go back on 20. On the side of the spreadsheet. Of the spreadsheet. Did he abscond? We can take the amount of 20,000 with 2 euros. Did he abscond?
He was in custody for 66 days and he was enlarged on bail on 9/6.
So whatever we said. This method. He submits that. For 2 days. For attending the shot ceremony. Shot ceremony, yes, to start. We have heard the learned process for the parties to start. We have noticed that the applicant was, no, we have heard the process. The applicant has been convicted by the court of the special judge bracket Poxo, Nalbari. While judgment dated 9/11/2021 in SPL bracket P case number 15 of 2020. Under section 376. Under section 6 of the POCSO Act, and sentenced to undergo simple imprisonment for 20 years with a fine of rupees 30,000, in default, SI for 6 months. The applicant, besides, the applicant, while filing the present appeal, had also filed an earlier application under section 389 bracket 1 CRPC for suspending the sentence and releasing the applicant on bail. The same was, however, rejected by this court-wide order dated 15/2/2023. The case number that just before that. 389. Being IA criminal 19/2023. Next paragraph. The present IA criminal 53 of 2024 has been made only on the ground that the applicant should be allowed to attend the shot ceremony of his father, which is to be held on 19/1/2024. On considering the issue involved, and keeping in view the submission of the learned APP, we allow. We are of the view that the application should be allowed only for a temporary period and on humanitarian grounds only. So stop accordingly. So the sentence will have to be suspended for 2 days. Accordingly, we grant temporary bail to the applicant. No, bail. Bail. Okay, we allow the applicant to be released on. Accordingly, we allow the applicant to be we allow the applicant to be released on bail to attend the shot ceremony of his father to be held on 19/1/2020. Accordingly, the CJM, the CJM null body is directed to release, to release the applicant under police protection on the morning of 19/1/2024. At 10 a.m., at around 10 a.m., at around 10 a.m., to enable him to attend the shot ceremony of his father. And should be taken back into judicial custody by 11 a.m. on 20/01/2020. Okay, evening. Evening. Nice people will come. Evening. Evening by 8 p.m. 7 p.m. Before that. Before three. Okay, and be taken back to the prison on or before, no, by by 5 p.m. on the same day.
Not on the same. Next.
Oh,
Next.
On the next.
so then you did 4 p.m. of the next day. That is 20/1/2020.
Lordship, on the morning of 19/1, can it be at 9 a.m.? Because Nalbari jail to Bhidia, it's a village. He's not in.
Okay,
It's
9 a.m. sounds, but will the court be there? It will be there. Yeah, by 9 a.m. 9 a.m. on 19. The the application is accordingly disposed of.